Hello, and welcome to part two of the Law of Negligence. So, in part one, we spoke about the duty of care owed between neighbours from one neighbour to the other. But that's just the first of four stages in a negligence test. And the stages that I want to talk about today are causation and foreseeability. So, thinking about tree root subsidence claims, there are often multiple possible causes which could all be contributing to crack damage to the claimant's property. It might be a neighbour's tree, it might be a leaking drain, it could be lintel failure, lack of lateral restraint, a poorly constructed extension, for example. So, site investigations and evidence, and possibly expert evidence, needs to be obtained to determine which cause was the material cause of the damage to the claimant's property. Presuming you've got the evidence in order to support that a tree is the cause of the damage to the claimant's property, then you have to consider what the foreseeability of the defendant was. Was the defendant able to foresee that their action or inaction with regard to their tree might cause damage to the claimant's property? And this is often where claimants become unstuck in claims where it's one neighbour versus another, because the test needs to be that the defendant was able to foresee the risk of that harm to the claimant's property before that actually occurred. But on the presumption that the claimant is able to show that the defendant's tree was the cause of the damage and that the defendant was able to foresee that risk of damage before it actually occurred, then you get on to the final stage, which is damages, monetary damages to compensate the claimant. So how much money can the claimant claim from the defendant? Well, they can claim damages to compensate them for a reasonable extent of repair works to their property, and then potentially general damages to compensate them for the inconvenience and distress suffered as a result of the subsidence claim. But if the claimant isn't able to show that the defendant's tree was the material cause and isn't able to show that the defendant was able to foresee the risk of subsidence damage to the claimant's property, then they will get no money. They will not get that monetary award of damages.